Hi, I'm going to be talking about a famous case in Canada. It's Gladue versus Canada. In 1999, in the case of Gladue versus Canada, a young woman by the name of Jamie Tanis Gladue appealed the court's decision in her sentence of second-degree murder of her common-law husband. The plaintiff's main claim is that the judge erred in not taking into consideration her Aboriginal descent. In Statute 718.2e, often referred to as the Aboriginal Sentencing Section, it mandatorily requires sentencing judges to consider all available sanctions other than imprisonment and to pay particular attention to the circumstances of Aboriginal offenders. It is supposed to be remedial in nature and is designed to combat the serious problem of the overrepresentation of Aboriginal people in prisons, and to encourage sentencing judges to take a restorative approach to sentencing. In sentencing an Aboriginal offender, the judge must consider the unique systematic or background factors which may have played a part in bringing the particular Aboriginal offender before the courts, and the types of sentencing procedures and sanctions which may be appropriate in the circumstances for the offender because of his or her particular Aboriginal heritage or connection. As well, if there are no alternative to incarceration, the length of the term must be carefully considered. The jail term for an Aboriginal offender may in some circumstances be less than the term imposed on a non-Aboriginal offender for the same offense. However, statistics have shown that it is actually the opposite of this that is true. Section 718.2e applies to all Aboriginal persons wherever they reside, whether on or off reserve, in a large city or a rural area. This is where the judge had made the error. The ruling judge of the case stated that because Gladue and the deceased have been living in an urban area and not on a reserve, that Section 718.2 did not apply to her, regardless of her self-identifying as Cree. Moreover, he does not appear to have considered the systematic or background factors which may have influenced the accused to engage in criminal conduct or possibly distinct conception of sentencing held by the accused by the victim's family and by their community. In his submissions on sentence at trial, the appellant's counsel did not raise the fact that the appellant was an Aboriginal offender, but when asked by the trial judge whether in fact the appellant was an Aboriginal person, replied that she was Cree. When asked by the trial judge whether the town of McLennan, Alberta, where the appellant grew up, was an Aboriginal community, defense counsel responded, "It's just a regular community." No other submissions were made at the sentencing hearing on the issues of the appellant's Aboriginal heritage. The reason why I draw on this particular aspect of the hearing is that through the current framework of the Canadian legal system, an Aboriginal must use their background and heritage as a defense strategy and must convince the court that being Aboriginal has led them to being on defending side of conviction hearing. However, with the wording of this particular hearing, an Aboriginal defendant must be living in extremely adverse conditions and or separate themselves from municipal communities to be accepted. They ignore the cultural conflicts that have occurred or how colonialism has put a strain socially and economically on many Aboriginal families. This opinion is one in which states that once you are not considered destitute, it is no longer the Canadian legal system's responsibility to consider the cultural factors that have led you here, and we will judge you on an equal basis as all other non-discriminated privileged white descendants and defendants. To add a caveat, while this is the principle we see, the cultural bias plays a part in decision-making, and that Aboriginal defendants will be convicted more often and for longer sentences than their non-Aboriginal counterparts. The Court of Appeal unanimously concluded that the trial judge had erred in concluding that Statute 718.2e did not apply because the appellant was not living on a reserve. The Gladue Report is a type of pre-sentencing and bail hearing report that a Canadian court can request when considering sentencing an offender of Aboriginal background under Section 718.2e of the Criminal Code. Gladue was the first case to challenge Section 718.2e of the Criminal Code. This is not an automatic get-out-of-jail-free card like many will say. Rather, it requires the court to take into account circumstances facing Aboriginal peoples. Where the crime is relatively minor, the court should consider Aboriginal-based sentencing principles such as restorative justice. However, where the crime is more serious, courts will generally find that the Gladue principle is inappropriate and consider more traditional sentencing objectives such as protection of the public and deterrence. Is there a bias in this? While the legal system has begun to use restorative justice in minor legal cases, they continue to use a penal system on Aboriginal defendants and yet wonder as to why the recidivism rate is so disastrously high, especially considering that the recidivism rate of non-Aboriginals is also shockingly high. Perhaps Canada's current legal system, based on punishment, but stating the lie that its purpose is rehabilitation and reintegration, needs to be revised and take into consideration how Canadian Aboriginals have traditionally dealt with crimes and delinquents.